The long-running legal and political fallout from the case of Jeffrey Epstein has taken another significant turn. The U.S. Department of Justice, DOJ, has returned to federal court in Florida, seeking permission to unseal grand jury testimony connected to the government's early investigation into Epstein nearly 2 decades ago. According to court filings, the DOJ argues that these materials are essential to fulfilling its legal obligation to release information tied to Epstein and his alleged associates. However, the request faces legal hurdles. Earlier this year, judges in both New York and Florida rejected similar attempts to make the grand jury records public, citing long-standing rules that protect the secrecy of such proceedings. One judge even suggested that the government may already possess substantial information that could be disclosed without breaching grand jury confidentiality, raising questions about why additional court approval is being pursued now. The issue is complicated by a recently enacted federal transparency law requiring the DOJ to release unclassified records related to Epstein and his network. While the statute mandates disclosure of investigative materials, it does not explicitly reference grand jury transcripts, documents traditionally shielded from release except under rare circumstances. Despite that ambiguity, the DOJ now maintains that the grand jury material falls within the spirit of the law and should therefore be unsealed. Officials are asking the court to act quickly, emphasizing that they face a looming statutory deadline to complete the disclosure process. The renewed legal push underscores the continuing national scrutiny surrounding how Epstein's case was handled, who may have been connected to him, and whether the public will gain access to long-protected investigative records. The Justice Department's renewed request comes as it faces mounting legal pressure to comply with federal transparency requirements tied to the Epstein investigation. Lawmakers and advocacy groups have argued that the government has already had ample time to organize, review, and release relevant records. With statutory deadlines approaching, the pace of disclosure has become a central point of criticism. Officials within the department maintain that the process is far more complex than it appears. They say millions of pages of investigative files must be carefully examined to ensure sensitive information, particularly material that could identify victims or compromise ongoing legal protections, is properly redacted. Such reviews, they argue, cannot be rushed without risking serious legal and ethical consequences. Critics, however, question whether the slow pace reflects caution or reluctance. They note that only a small portion of the requested material has been released so far, much of it heavily redacted. This has fueled suspicions among some members of Congress that the review process lacks transparency itself. The debate highlights a familiar tension in high-profile cases, balancing the public's demand for accountability with the justice system's obligation to protect witnesses, victims, and the integrity of sealed proceedings. Courts historically guard grand jury secrecy closely because witnesses testify with the understanding that their statements will remain confidential unless extraordinary circumstances justify disclosure. As judges weigh the DOJ's latest arguments, the case has evolved beyond a routine records dispute into a broader test of how far transparency laws can reach into traditionally protected areas of the legal system. While the matter plays out in court, members of Congress from both parties have increased oversight efforts, signaling frustration with what they describe as delays in producing information. Congressional committees have issued subpoenas and formal requests seeking clearer timelines and explanations from the Justice Department. Lawmakers argue that public confidence depends on demonstrating that no individual, regardless of wealth or influence, received special treatment during earlier investigations into Epstein's activities. The bipartisan tone of the criticism is notable, reflecting how the issue has resonated across ideological lines. Some legislators have raised the possibility of holding officials in contempt of Congress if they determine that lawful oversight requests are not being met. Though such measures are rare and typically used as a last resort, even discussing them underscores the seriousness of the standoff. Justice Department representatives have responded that they are cooperating within the limits of the law and emphasize that document production must follow established review procedures. They caution that politicizing the process could risk undermining legal safeguards designed to ensure fairness and accuracy. This push and pull between legislative oversight and executive authority is not unusual in sensitive investigations. However, given the notoriety of the Epstein case and long-standing public skepticism about how it was handled, the confrontation has drawn unusually intense attention. One of the central practical challenges cited by officials is the sheer scale of the material involved. Investigations spanning multiple jurisdictions over many years generate extensive documentation, interview transcripts, financial records, internal communications, and legal filing. Each document must be evaluated individually to determine whether it can be released under federal disclosure laws. That includes identifying information protected by privacy statutes, court orders, or victim rights provisions. Legal analysts note that such reviews often take months or even years in complex cases, especially when agencies must coordinate across departments. In addition to privacy concerns, prosecutors must ensure that releasing certain information does not interfere with related cases, appeals, or sealed agreements. Even historical investigations can contain references to individuals who were never charged, raising reputational and legal concerns if their names are disclosed without context. Transparency advocates acknowledge these difficulties, but argue that clearer communication from the government would help ease doubts. Regular updates, they say, could demonstrate progress while maintaining necessary confidentiality. The dispute therefore reflects not only disagreement over what should be released, but also how the process is explained to the public, a factor that often shapes perceptions as strongly as the documents themselves. As the timeline stretches, the controversy has inevitably taken on political overtones. The case has become part of broader national conversations about institutional accountability, elite influence, and public trust in law enforcement agencies. Supporters of faster disclosure say releasing the files could help resolve lingering questions about who interacted with Epstein and whether earlier investigations missed opportunities for action. Opponents of rushing warn that incomplete or poorly contextualized releases could lead to speculation and misinformation. Because Epstein had connections in business, politics, and social circles, any document release is likely to attract intense scrutiny regardless of its actual legal significance. Experts caution that association mentioned in investigative material does not necessarily imply wrongdoing, a distinction often lost in public debate. The Justice Department must therefore navigate not only legal standards, but also the risk that partial information could be misinterpreted. This balancing act between openness and responsibility has made decision-making especially delicate. Responsibility for overseeing the department's response ultimately rests with Attorney General Pam Bondi. As the nation's top law enforcement official, she must reconcile competing demands from courts, Congress, and the public while ensuring compliance with federal law. Bondi has stated that the department is committed to transparency, but insists that any disclosures must respect legal protections for victims and adhere to judicial rules governing sealed testimony. Her position reflects the institutional caution typical of attorneys general dealing with sensitive historical cases. Nevertheless, critics argue that leadership must do more to demonstrate urgency. They contend that high-profile investigations require visible accountability measures to maintain public confidence. Observers note that attorneys general often face difficult choices when legal obligations intersect with political realities. Decisions about what to release, when to release it, and how to explain those actions can carry long-term implications not only for a single case, but also for the credibility of the department itself. At the heart of the dispute lies the interpretation of the federal transparency statute requiring disclosure of Epstein-related records. Legal scholars say the law's language leaves room for debate, particularly regarding whether grand jury materials fall within its scope. Grand jury secrecy is deeply embedded in American jurisprudence. Courts generally allow disclosure only under exceptional circumstances, such as when evidence is needed for another judicial proceeding or when historical interest outweighs confidentiality concerns. The DOJ's argument is that Congress intended broad transparency, and that courts should therefore permit limited unsealing consistent with that goal. Opponents counter that altering grand jury protections could set a precedent affecting future cases far beyond Epstein. Judges must now determine whether the public interest in disclosure justifies modifying those long-established rules, a decision that could influence how similar requests are handled nationwide. Beyond the legal technicalities, the outcome may shape how Americans view government accountability in high-profile criminal matters. Epstein's case has long symbolized concerns about unequal justice, making transparency efforts particularly consequential. If additional records are released, they could either clarify past decisions or deepen debate, depending on what they reveal. If courts deny access, critics may argue that secrecy continues to overshadow accountability, even if the decision follows established legal doctrine. Public trust often hinges less on the specific findings of an investigation and more on whether institutions appear open and responsive. That reality places added weight on how officials communicate their actions during the disclosure process. Legal experts emphasize that maintaining confidence requires both adherence to the law and clear explanations of why certain information can or cannot be shared. The next phase depends largely on how federal judges rule on the DOJ's request to unseal grand jury testimony. If approved, the department would begin a carefully managed release process, likely involving further redactions and staged disclosures. If denied, the government may need to rely solely on other records to meet its transparency obligations. Meanwhile, political attention is expected to remain high, particularly as lawmakers continue oversight efforts and advocacy groups press for maximum disclosure. The controversy also intersects with the broader legacy of Epstein's relationships and investigations, including past associations involving prominent figures such as Donald Trump, which have already been publicly documented and examined in various proceedings. Any additional references in newly released material would likely be analyzed within that existing context. Ultimately, the case represents a complex intersection of law, politics, and public accountability. Whether the final outcome results in significant new revelations or primarily procedural clarification, the process itself is shaping an important national discussion about transparency, justice, and the limits of disclosure in the American legal system.